We're back with more breaking news. We are seeing the fallout this morning from the Supreme Court's ruling on Louisiana's congressional map. Louisiana Governor Jeff Landry is now planning to postpone 6 congressional primaries that are currently just 2 weeks away so that state lawmakers can draw a new map. This is according to 4 people with knowledge of the matter who spoke to MS Now. The governor says they are regrouping to figure out the path forward, but primaries won't be going ahead as planned in May. The High Court's decision to strike down Louisiana's congressional map, ruling the state violated the Constitution when it reworked the map to preserve black majority districts, drawing outrage from Democrats and voting rights groups.
They've tried to do everything that they can to eliminate and erase our journey, our struggle, our march.
The Supreme Court has opened the door to a coordinated attack on black voters across this country.
This is Jim Crow in new clothes.
Let's bring in MS Now senior legal reporter Lisa Rubin and MS Now legal analyst Melissa Murray. She teaches constitutional law at NYU. Lisa, this announcement from Louisiana postponing the primary, already we're seeing these ripple effects from the Supreme Court's decision. What kind of new legal can of worms was just open?
Well, first of all, the Supreme Court announced a new test for showing that Section 2 of the Voting Rights Act has been violated. And I think I and others yesterday have said it has made it virtually impossible for a plaintiff to meet that test. And I want to just illustrate to you why. The first thing that plaintiffs have to do if they want to show that a map is violative of the Voting Rights Act is they have to provide an alternative illustrative map that meets all of the state's enunciated non-racial goals that include things like incumbency protection. And they have to draw those alternative maps without being cognizant of race. Justice Kagan in her dissent essentially says, how is anyone supposed to do that? That is an all but impossible task. And the test goes on from there. So first and foremost, the new legal can of worms is how is a plaintiff supposed to show that Section 2 has been violated? But the second question is there are up to 15 congressional districts throughout the country that NPR, according to a prior analysis, believed could be at risk if the court ruled in the way that it did. And now you are starting to see folks in other states calling for new primaries. Now, in some places, filing deadlines, primaries have long since passed, but you have lawmakers and candidates in Tennessee and in Georgia asking for new districts already.
Wow, and that, again, affecting this year's midterm elections. I want to dig a little bit more into the Supreme Court's decision. In the majority opinion, Justice Alito writes that Section 2 of the Voting Rights Act was designed to enforce the Constitution, not collide with it, adding that the lower courts have applied it in a way that forces states to engage in the very race-based discrimination that the Constitution forbids. But as Lisa noted in her dissent, Justice Kagan argues it renders the Voting Rights Act all but a dead letter. Melissa, what changes can people expect? Talk to those voters right now. What's going to happen? What does this mean for the power of each and every vote?
Well, I think we have to separate this majority decision, which is very much in keeping with what this court has been doing for the last 20 years, which is advancing this theory of colorblind constitutionalism, the idea that the Reconstruction Amendments, the 13th, 14th, and 15th Amendments, are absolutely colorblind. That is kind of nonsensical if you take the origins of those amendments seriously. They were born in the aftermath of the American Civil War for the purpose of integrating the formerly enslaved into the political community. They were anything but colorblind because they recognized that they were intended to address the longstanding vestiges of enslavement that could be resurrected in the South and elsewhere after the Civil War. So they were very much color conscious, and Justice Alito, in this opinion, is essentially doing what we saw the court do a few years ago in the Students for Fair Admissions decision, saying that any consideration of race, even for the purpose of remedying past racial discrimination, whether in education or in voting, is absolutely verboten. So it is a very odd and skewed understanding of the Constitution, and Justice Kagan has made this very clear. Moreover, it is a contradiction of what Congress, the representatives of the people, chose to do in the Voting Rights Act in 1965 and in its reauthorizations. Congress has made clear that it wants to be able, in its power, to address and enforce the terms of the 14th and 15th Amendments to address the ongoing scourge of racial discrimination in voting. And this court has basically made it impossible for Congress to do that going forward. It is going to take a massive outlay of voter activity and action in the midterm elections and going forward to be able to counteract this. But again, I don't think it's impossible. The court has just made it harder.
Lisa, I want to pick up on something you said. Do we just expect now more and more states to jump on the redistricting bandwagon because of this ruling? Are there any guardrails left when it comes to redistricting?
Well, there's supposed to be guardrails, but again, they are guardrails that the courts have put on themselves that may advantage states who want to do redistricting, and that's because of a decision called Purcell. The Purcell principle is the idea that courts cannot change the rules for elections too close in time to an election because it's confusing to voters and to administration officials. But that also means that if a state changes the rules of the game late in time, and that means that the litigation percolates very close in time to the election, the court may decide that the status quo, meaning the rule that has been passed by a state, is what has to stay in place, not what existed beforehand. So if anything, the way that this court's precedents are structured may further disadvantage people who want to challenge late-breaking redistricting implementation.
And just yesterday in Florida, state lawmakers passed new maps that were proposed by Governor Ron DeSantis that create 4 more Republican-leaning seats. But Florida's state constitution actually has a provision that effectively bans drawing districts just to benefit one party or a particular candidate. Melissa, is this legal barrier enough to halt this Florida redistricting effort?
Well, it will certainly be challenged. And again, I think what's happening in Louisiana, Governor Landry is about to get sued, and I think he likely knows that. A lot will depend on what happens in the court system in those states, going up to their high courts. But yes, these are going to be subject to legal challenges. So it's not obvious that this will have an immediate impact on the midterm elections, but it will have a very pernicious impact on elections going forward. And I think one point has not been emphasized here. This question of whether this kind of racial remedy in redistricting violates the 14th or 15th Amendments is a question that the court injected here. None of the litigants were asking for this. This case was supposed to be decided last term. The court held it over for re-argument in this term and then subsequently asked for the litigants to brief this particular question. This is a question that the court wanted to get to. It wanted to make this decision. It wanted to do this, and we should not lose sight of that. It did not have to answer this question. It chose to put it on the table, and it chose to answer it in the way that it did.